3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through Isby versus JP Morgan. Today, we are following the 2024 document releases through the documentary record so that timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm, so start with court unsealing process. That is where the paper trail becomes specific and testable.
We need to set the parameters immediately. This is not a speculative discussion. This is a forensic audit of the 2024 document releases. We are analyzing the metadata, the file integrity, and the chain of custody regarding the Department of Justice's release pattern.
So we're looking at the digital footprint, the bureaucracy itself.
Exactly. Not just what was released, but how, and more importantly, what was retracted after the fact.
Agreed. The constraint for today is strict. What do the documents actually prove? What remains unproven? And where are the specific institutional decision points?
Let's start with the release mechanism.
Okay, so this wasn't standard document dump. It wasn't, just a box being overturned. We have to look at the pinpoint database of U.S. Justice Department's Epstein Files,
Which is managed by the Courier Newsroom.
And that's a critical detail.
It's the whole ballgame. The Courier Newsroom archive, it acts as our control group. In any forensic review, you need a baseline, something to measure against. Without their archive, we'd only have the DOJ's current, let's call the official version of the repository.
A sanitized version.
That's one word for it. The record shows a very specific pattern that Courier identified and crucially captured. They call it a pattern of release and delete.
Okay, let's break that down. Release and delete. You're talking about the sequence of events recorded in August of 2024.
I am. The source documentation confirms it. The U.S. Justice Department began uploading documents and multimedia files. These were official uploads to their public-facing server.
Not leaks.
No, absolutely not.
Yeah.
They appeared on the server, live, accessible, and then shortly after, they were removed. Deleted. But not before they were archived.
Right. Courier Newsroom retained the files during that window of availability.
Which lets us perform a delta analysis, a comparison. We can see what the DOJ initially released or maybe accidentally made public and compare it against what they decided retroactively should not be public.
We have specific serial numbers for these files, too. I'm looking at a document here, EFTA 02335898.pdf, and another one, EFTA 02730741.pdf.
And look at the acquisition date listed in the pinpoint database.
2024-08-14, August 14th.
August 14th, 2024. That date is, well, it's very significant. It's well past the official closing of the case, which is a whole other decision point we need to get to.
We will.
But just looking at those serials for a second, of EFTA, that prefix usually denotes a specific agency archive, a task force. The fact that these files exist in the Courier archive but are absent from the current DOJ site, that's what we call a documented discrepancy.
It's a mismatch between the master file and the public record.
It is a testable, provable mismatch.
And the content of these deleted files isn't random. The source documentation notes that the items that were pulled back specifically connected Epstein to President Donald Trump.
And we have to state that very neutrally, exactly as it appears in the record, the files that were selected for removal contained those specific keywords and associations. Now, the logs don't state why.
Right. It could be a legal privilege review, a privacy redaction.
An error. It could be a simple error. We don't have documentation for the motive. However, the selection of the material for deletion, that's a data point in itself.
It suggests the filter is active.
It's active and it's reactive. This isn't a static release of historical records from a dusty box. It's an ongoing curation process happening in 2024.
Which really changes the whole nature of this unsealing process.
It implies administrative friction. If the mandate was total, simple transparency, the files would remain online. The removal indicates that someone, somewhere inside the DOJ, flagged these specific serial numbers for retraction after the initial upload.
And that's the decision point.
That is the decision point we are tracking. Who made that call and based on what criteria? The documents don't tell us that, but they prove the call was made.
Okay, so let's move to the structure of the data that did remain. The data that was cataloged, the pinpoint database organizes all of this into what they call data sets.
And this is where we start to see the scale of what might be withheld. The records, they verify the existence of data sets 1 through 8.
Okay, I see that in the log. 1 through 8 are accounted for.
And we also have verification for data set 12.
So it jumps.
It jumps, which immediately forces the question about the sequence gap. We do not have documentation for data sets 9, 10, and 11.
So they're just unaccounted for, completely missing from the upload logs.
As of the audit date we have, January 31st, 2025, yes, they are missing from the sequence. And in any kind of forensic accounting, or federal discovery for that matter, a gap in sequential numbering, that's a major red flag.
You don't just skip numbers.
You don't skip numbers, not in invoices, not in check numbers, and certainly not in evidence batches. It represents a volume of information that was either processed and then withheld entirely, or is processed and moved to the different and non-public archive.
And we have no idea the size of those missing sets.
We don't. But if we assume they're comparable in size to, say, data sets 1 through 8, we could be talking about thousands of pages.
A substantial void.
A substantial void in the evidentiary sequence. It's a black box sitting right in the middle of the timeline.
Let's look inside the boxes we do have. The metadata tags in the pinpoint database, they give us a kind of architecture of Epstein's digital life. I'm seeing entity tags for the Federal Bureau of Investigation, obviously. Apple, Bradford Limited.
Bradford Limited is a key one. It's a corporate entity that shows up again and again in the financial webs. But I want to focus on the hardware and software tags. For me, that's where we see the real age of this evidence.
Okay, I see Compaq, and another one, Book for You.
Compaq, right there. That's a hardware tag. That single word dates the origin of the forensic image we're looking at. Compaq, as a major independent company, effectively stopped existing after the HP merger.
Which was, what, early 2000s? 2002?
Yeah, exactly. So when you see a Compaq tag in a 2024 document release,
it confirms you're looking at digital forensics from the very earliest era of his operations.
The late 90s, the very early 2000s.
Yeah.
This isn't data from the cloud. This is data pulled from a physical hard drive, physical media that was seized, imaged, and is only now being processed for public release decades later.
And what about Book for You?
It's likely a proprietary software directory, or maybe a legacy contact management system, something custom. It indicates the specific digital tools Epstein was using to manage his network.
This level of metadata is unusual.
It's very rare. Usually we just get a PDF of a scanned, printed document. To see the system tags Compaq Book for You, that tells us the DOJ is processing the native files, the original digital material.
Which means they have the original directory structures, the folder names, everything.
They have the machine state. They know not just what was written, but when it was created, what machine it was created on, using what software. They possess the entire digital environment, not just the text within it.
And the locations tagged in the metadata, United States, of course, but also Austin, Cranston.
Right. And these geographic tags, they correlate to flight patterns and property records we've seen in other document tranches. But their appearance here in the digital file metadata, that's different.
It links the physical location to the digital act.
It anchors it. It means someone was sitting at a computer in Austin or in Cranston, creating these files on an old Compaq machine. It connects the digital evidence to the physical world in a way a simple document can't.
Okay, let's shift to evidence block 3, the names. The headline-grabbing part of these releases. The 2024 releases, combined with the earlier 2015 tranches, they confirm a lot of the individuals we already knew about.
The established list, yes.
Yep.
Prince Andrew, Alan Dershowitz, Bill Clinton. Those names are confirmed in multiple sources. They're part of the broad documentary record now.
The headline names.
They are. But for this audit, we need to look past them, at the new names that are appearing in the 2024 metadata.
I see them here. Alfredo Rodriguez and Carlos Perez.
Exactly. These names are showing up in the pinpoint database metadata. These are not headline names. These are, well, they're likely support staff.
Pilots, household facilitators.
Could be drivers, schedulers, IT maintenance, and their significance is enormous.
Because an operation like this requires logistics.
It's pure logistics. A trafficking network is an infrastructure project. The appearance of names like Rodriguez and Perez in the metadata suggests the core investigation files contain testimony or employment records from that operational tier, not just the guests on the plane.
The infrastructure of the crimes.
Yes, and that's often where the most damning, verifiable evidence is found, in the mundane records of the people who made the machine run.
And yet, while we're getting these new lower-level names unsealed, we still have pseudonyms like Jane Doe 3 appearing.
And this is the core tension in all of these unsealing orders. The public narrative is one of transparency, of naming names, but the legal reality is much more complex.
The protective orders are still active.
For victims, for certain witnesses, absolutely. Jane Doe 3, appearing in the 2024 metadata, confirms that. The unsealing is not a blanket process.
I'm looking at another document serial here, EFTA 0273-0486.pdf. The status on this one is listed as access denied you.
Access denied you. Now, the U in government markings typically stands for unclassified, so this is a specific category of withholding.
It's not a national security issue.
No, it's not a classification or clearance issue. It's a privacy hold or a relevance objection. Something is being shielded for reasons other than state secrets.
And we actually have the justification text in another document, EFTA 02335898.pdf. It's quoted right here.
What does it say?
It says, production not necessary. Documents are not relevant or you. Document does not exhibit the mental impressions of.
Stop there. Mental impressions. That's the key. That is work product legal terminology. It's a very specific legal doctrine.
So this suggests that some of these withheld documents, they're attorney's notes.
Or internal prosecution strategy memos. Deliberations. The thought process of the case itself.
So they aren't direct evidence of the original crime. They're evidence of how the case was built or not built.
Precisely. The government is shielding the internal deliberations of its own prosecutors, or perhaps the defense. The phrase production not necessary is an administrative decision, not a legal one handed down by a judge. It means someone within the DOJ has decided that the public's interest in seeing that specific page does not outweigh the institutional privilege of the author.
But that fundamentally contradicts the public narrative of unsealing, doesn't it? If the headline is Epstein Files Unsealed, but the audit trail shows potentially thousands of pages are being held back as not relevant or as mental impressions,
then what we're seeing is not the full picture. We are seeing a curated selection from the archive. The unsealing is the legal procedure, but the redaction and withholding, that is the administrative reality. And the audit trail proves significant content remains shielded.
Let's reconstruct the timeline now. To understand how these 2024 digital decisions fit, we have to look at how the physical evidence has been handled, starting from the moment of Epstein's death.
We have to go back to 2019 and early 2020. There's contemporaneous reporting from January 17, 2020 that details the immediate aftermath.
This is where the dispute over the pathology comes from.
Yes. Dr. Michael Baden. He was the forensic pathologist hired by the family to observe the autopsy. His testimony is what created the conflict.
He cited the breast capillaries in the eyes.
Petechial hemorrhaging. He claimed on the record that this finding was more consistent with homicidal strangulation than with a drop-hanging suicide, which is the official cause of death.
So from day one, we have a fork in the road.
From day one. The documents show conflicting pathology reports. We have the official ruling of suicide from the city's medical examiner, and we have a contemporaneous contradictory claim from an expert witness who was physically present at the autopsy. It's a fundamental disagreement on the core fact of the event.
And what about the physical evidence from the jail itself? The surveillance cameras?
This is the critical custodial failure. The reporting from that same period confirms it, and it's never been credibly refuted. Surveillance video from Epstein's first suicide attempt erased.
And to be clear, this was the video from the attempt that happened before his death.
Correct. The incident a few weeks prior where he was found semi-conscious in his cell. The video of that event, which would have shown who entered or left his cell area around that time, was reported as erased.
And the explanation was?
A clerical error, a technical glitch. The justifications have varied, but the result is the same. The evidence is gone.
Now connect that specific event in 2019 to our findings about the 2024 document release.
It's a continuum of behavior. In 2019, we have the confirmed erasure of custodial video evidence from a high-security federal facility, a physical asset. In 2024, we have the confirmed release and delete pattern of digital documents by the Department of Justice, which was caught by Courier Newsroom, a digital asset.
It's the same pattern, just different media.
It establishes a repeatable pattern of data loss regarding key custodial evidence. Whether it's a videotape from the MCC or a PDF of a flight manifest on a DOJ server, the documented pattern is that the government possesses data that subsequently vanishes from the public record.
The timeline then shifts in July 2020.
Right. Ghislaine Maxwell is arrested in New Hampshire.
After being in hiding for about a year.
And this marks a critical transition in the entire case. The investigation pivots. It is no longer the Epstein case. It is now the Maxwell prosecution.
And that allows for a compartmentalization of the evidence.
Of course, once Epstein is dead and Maxwell becomes the sole prosecutorial target, evidence is filtered through a new lens. Is it relevant to convicting her? Evidence that was relevant only to him or to his vast network of other associates.
That can be deprioritized.
It can be deprioritized, or, as we see with those production not necessary tags, it can be formally deemed irrelevant to the act of prosecution. The focus narrows, and a lot of material gets left on the cutting room floor.
Let's talk about the decision to close the case entirely. There's reporting from June 28, 2023.
Yes, the headline was definitive. Gov closes case on Epstein.
So that's mid-2023. The book is closed officially.
June 2023, that's the public statement.
The pinpoint database, the one we've been auditing, shows the acquisition of new document serials in August of 2024. A full year later.
This is inconsistent.
To say the least. If the case is closed, why is the system still processing new serials? Why is it acquiring documents?
The metadata is unambiguous, acquired on 2024-08-14. Now, there are a couple of possible explanations. One is that these are archival processing dates, meaning they're just now getting around to scanning and logging old files for the unsealing process.
Okay.
The other explanation is that the closure of the case was a public relations or administrative status, and it did not actually stop the internal movement and processing of data related to the investigation.
So the case might be closed to the public, but it's not closed inside the DOJ servers.
The government is still actively handling this material, generating new acquisition tags in its own database, more than a year after telling the public that the book was shut. It's a direct contradiction.
Now let's look at another institutional decision point, this one outside of law enforcement, the institutional funding. We have to look at the MIT Media Lab.
This is a critical piece of the puzzle because it demonstrates the complicity, the broader institutional failure. The reporting details MIT's decision to continue accepting funding from Epstein.
And the justification they offered.
The founder claimed that taking the money was justified. And this is the crucial part. This was happening after Epstein's 2008 conviction in Florida. This wasn't before he was a known sex offender. This was after.
So we have a timeline where federal video evidence is being erased.
Yes.
The DOJ is actively deleting its own released files in 2024.
Correct.
And one of the world's premier scientific institutions is simultaneously justifying taking millions of dollars from him, knowing his status as a convicted offender.
It places the DOJ's failures in a much broader context. The rot wasn't just in the jail or in the prosecutor's office. The financial permeability of these elite institutions is what allowed Epstein to operate with impunity for so long. The audit of institutional failures have to include entities like MIT because the money was accepted knowing the source. It was a conscious decision.
Okay, let's move to evidence block 6. The unresolved gaps, the things we know are missing from the record.
We have to address the specific claims of missing evidence.
There's an interview from January 12, 2024. It's with Jeffrey Epstein's brother, Mark Epstein.
Right. And in that interview, Mark Epstein lists very specific pieces of evidence that he claims the feds are covering up, specifically related to the death scene.
He talks about photos, a hyoid bone. He's very specific.
He is. Now, we have to be extremely precise here in our audit. We don't have documentation for the specific inventory that Mark Epstein lists.
Yeah.
We cannot independently verify his claims about those items. But his central claim, that there is a cover-up, is happening in a context that we can document. His claim is corroborated by the proven erasure of the jailhouse surveillance video and the proven existence of conflicting autopsy notes from Dr. Baden.
So while we can't verify his specific list of missing items, the environment of his claim is supported by the forensic record we've already established.
Exactly. His claim is not being made in a vacuum. It is being made in a documented environment of systemic data loss and conflicting official records. That gives his claim a weight it would not otherwise have.
And that brings us to the flight logs.
The flight logs. There's a source from August 12, 2019, just after Epstein's death, that frames the question perfectly.
The topic was the logs, but the specific question was what vanished?
What vanished? And that's still the question. The logs themselves exist, at least in part. We have lists of names. We know many of the powerful people who flew on his planes.
We know who flew. We still don't know why.
That's it. The context is what vanished. The 2024 release gives us metadata. It gives us these fascinating tags like Book for You and Compact, but it does not provide the investigative narratives, the FBI 302s, the witness interviews that would explain the purpose of these flights. We have thousands of data points, but the Department of Justice has not released the connective tissue that would turn that data into a story.
So let's synthesize this. Let's bring the entire audit together. We've walked through the documentary record.
Wow.
We have a clear timeline. It starts with erased video evidence from the jail in 2019 and 2020. A key piece of physical evidence is gone.
Gone. With an official explanation that doesn't hold up to scrutiny.
Then, in mid-2023, we have a public declaration from the government that the case is officially closed.
A line is drawn in the sand.
And then, a year later, in 2024, we see this subsequent erratic release of documents, a process where the Department of Justice itself is caught actively deleting files that it just made public.
The pattern is not one of transparency. It's a pattern of what can only be described as administrative friction.
Friction.
Yes, resistance, an institutional resistance to full disclosure. The documents prove, without a doubt, that the DOJ possesses more data than it retains in the public record. We know this for a fact because Courier Newsroom caught them deleting it.
We also know it because of the gaps.
We know it because datasets 9, 10, and 11 are missing from the official log. A huge, unexplained hole in the middle of the evidence.
So this whole unsealing process is, what? A performance.
It's a selective process. That's the most neutral way to put it. It is not a total dump of the archive. It is a highly curated release, subject to production not necessary tags, access denied flags, and, as we've seen, active deletion of politically sensitive connections after the fact.
The documents do confirm some things. They confirm new names on the operational level, like Rodriguez and Perez. They confirm the existence of these vast data sets. But the gaps, the deletions, that seems to be the real story.
The gaps are where the institutional liability resides. From the physical jail cell in 2019 to the digital server room in 2024, the documented continuity is one of evidence destruction or suppression.
Next time, DOJ 3.5 million pages.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.